여러분,
The International Symposium co-hosted by the 송상현 Foundation and the Korean Society of International Law welcomes you. Good afternoon. I am Kim Tae-hee, the MC for today's symposium. Today's symposium aims to engage with domestic and international experts in discussing the legal implications of North Korea's military involvement in Russia's war in Ukraine. We're going to look at this issue in a different light so we can discuss this issue in the political matter and also academic matter. So we have prepared diverse presentations and discussions, so please remain seated until the end of the symposium. Now, we will begin the International Symposium jointly hosted by the 송상현 Foundation and the Korean Society of International Law. Firstly, I'd like to introduce our distinguished guests in attendance today. As your names are called, please stand and greet the audience. We kindly ask all attendees to welcome them with a warm round of applause. First of all, Dr. 송상현, of the former president of the International Criminal Court. Please give him a round of applause. Thank you. Next, Chairman Kim Yong-deok of the 송상현 Foundation for International Justice, Peace and Human Rights. And we have President Park Byung-do of the Korean Society of International Law. We have former Judge Kwon Ho-gun of International Criminal Tribunal for former Yugoslavia. We have former Chairman Kim Hyun of the Korean Bar Association. And we have Professor Marko Milanovic from School of Law of University of Reading. And we have many other distinguished guests. And let's give them a warm round of applause. That concludes our introduction of guests. Next, I would like to explain the format of today's symposium. The symposium will begin with part 1, which will include the opening remarks and welcoming remarks. And then in part 2, it will consist of thematic presentations organized into 3 sessions. The first session will address the topic issues concerning the establishment of an ad hoc tribunal for the crime of aggression against Ukraine. The second session will cover legal status of North Korean POW, and the final session will focus on DPRK as a principal or an accomplice. You can also refer to the booklet that we have prepared for you. Now we will begin with the opening remarks. The opening remarks will be delivered by Chairman Kim Yong-deok of the 송상현 Foundation. Please join me in welcoming him with a warm round of applause.
Good afternoon. I am Yong-deok Kim, Chairman of the 송상현 Foundation for International Justice, Peace and Human Rights. Thank you for participating in this international symposium despite your busy schedule. Many people have come from home and abroad. And especially Song Sang-hyun, former president of the International Criminal Court, who prepared welcoming remarks, and Professor Marko Milanovic for prepared presentation. My special thanks goes to you. And thank you, Byung-do Park, President of the Korean Society of International Law, for co-hosting this event. Many experts are here with us today. So would like to thank each and every one of you, but due to the interest of time, let me just extend my gratitude to all of you here today. 송상현 Foundation is based on the philosophy of justice, peace, and human rights, and was built in 2022 to create a just society. And in November 2022, it held the first symposium on justice, peace, and human rights to achieve via the International Court of Justice, and held the second symposium in November 2024, themed Searching for Ways to Recover Judicial Justice. And today we are holding joint symposium with the Korean Society of International Law on legal implications of North Korea's military involvement in Russia's war in Ukraine. It's 21st century, the civilization has developed, but armed conflicts still exist, threatening human peace. And Israel-Hamas war that began in October 2023 was halted in January last year, but January this year, but Russia-Ukraine war, which started on February 24th in 2022, has been prolonged for 3 years. And North Korea not only supported weapons but dispatched its troops in October 2024, and this was officially confirmed this April. And 송상현 Foundation holds a seminar on international humanitarian law with Korean Red Cross every year since 2023, and has identified international law and humanitarian issues, including armed conflicts. But since North Korea dispatched troops and North Korea POW issues are direct agenda items that we need to discuss. So in today's symposium, we would like to discuss issues concerning the establishment of an ad hoc tribunal for the crime of aggression against Ukraine, legal status of North Korean prisoners of war, the DPRK as a principal or as an accomplice, and we will deal with trial procedures based on international law to punish Russia's crime of aggression, humanitarian treatment, including repatriation of North Korean prisoners, legal restrictions on North Korea for its assistance to the crime of aggression, so that many experts can share their insights. And I'd like to thank our presenters, Taehyun Che, Professor Emeritus of Law at Hanyang University, Yong-ho Lee, Professor at Yeongnam University, Marko Milanovic, Professor at University of Reading, and our moderators, Chol Gyu-hwang, immediate past president of International Association of Prosecutors, Seo Yong-chung, Professor at Korea University, Keun-Kwan Lee, Professor at Seoul National University. And I cannot leave out discussants, Jin Kim from Kyunghee University, Yoon-jae Lee from Myungji University, Bum-seok Baek from UN Human Rights Council, Hwae-dong Kim, Professor at Korea Military Academy, Seung-hyun Nam from Global Governance Studies, and Ethan Hee-seok Shin from Transitional Justice Working Group. I hope we can identify legal issues after a discussion and raise awareness in the international society and academic society. So for successful hosting of this international event, many institutions and stakeholders have put their efforts, and we didn't have enough time or resources, but thank you, Secretary General Park Kun and 송상현 Foundation's working level staff. I wish for your health and happiness, and this wraps up my opening remarks for the International Symposium co-hosted by 송상현 Foundation and the Korean Society of International Law. Thank you so much.
Thank you, Chairman, for your opening address. Please return to your seat, Chairman. Next, we will hear the welcoming remarks. The welcoming remarks will be delivered by the President Park Byung-do of the Korean Society of International Law. Please welcome him with a round of applause. Good afternoon. It is a great pleasure to welcome you to today's International Symposium. I am President Park Byung-do. Today, we are opening an international symposium to discuss the legal implications of North Korea's military involvement in Russia's war Ukraine. And I sincerely thank you all esteemed domestic and international participants for joining us today. I would also like to extend my deep gratitude to Mr. Kim Yong-duk, chairman of the 송상현 Foundation, and Dr. Song Sang-hyun, former president of the International Criminal Court, for organizing this meaningful event. As the war in Ukraine continues to reshape the modern international order, North Korea's involvement raises complex international legal issues that demand in-depth analysis and discussion. This symposium will focus on key legal topics such as the establishment of a special tribunal for the prosecution and punishment of the crime of aggression, and the legal status of North Korean prisoners of war, and the question, is North Korea an accomplice or principal perpetrator in the Ukraine war? Aside from these legal issues, I must emphasize that North Korea's military support for Russia constitutes an international wrongful act. Russia's invasion of Ukraine is an act of aggression that violates a jus cogens norm under international law. The 2001 draft articles on responsibility of state for internationally wrongful acts adopted by the International Law Commission and recognized as customary international law clearly state that no state shall aid or assist another state in breaching such peremptory norms. Furthermore, any state that provides such assistance incurs international legal responsibility. Russia's invasion of Ukraine constitutes an act of aggression and therefore a violation of peremptory norms of international law. As such, no state may support or assist this violation, nor may any state recognize or approve such an unlawful act. Furthermore, Russia has violated the obligation to refrain from the use of force, which is an obligation owed to the international community as a whole. This means that all states, not only the injured state Ukraine, are entitled to invoke Russia's international responsibility. Accordingly, North Korea, by supporting Russia, also bears international legal responsibility for violating erga omnes obligations owed to the international community as a whole. The international community today faces many threats to global peace and security beyond the Russian-Ukraine war, the ongoing humanitarian crisis in Gaza caused by the Israel-Hezbollah conflict, the South China Sea territorial disputes, tensions in the Taiwan Strait, the Kashmir conflict between India and Pakistan, the civil war in Sudan, and more. Now, more than ever, war is spreading like virus. This morning, ballistic missile was sent by Iran, and I saw this in the news this morning, and I was devastated. Iran and Israel's conflict, and looking at their practice, I feel that the international law is less effective than ballistic missiles. However, we have to stand up and do something. For a peaceful international community, we have to continue our effort and find what international laws can do. And I think today we are here to discuss just that. The speakers today, former president of the Korean Society of International Law, Dr. Choi Tae-hyun and Lee Yong-ho, are among the most respected authorities in this field. Their in-depth presentations will provide us with lots of knowledge and insights. And also, our discussion will contribute to world peace and justice around the world. I also expect today's discussions to serve as an opportunity to explore practical legal alternatives under international law. I look forward to vibrant discussions among participants and meaningful progress in exploring legal responses under international law. Once again, I sincerely thank all of you for attending today's symposium. And Secretary General Park Kun and also the foundation, I would like to thank you for organizing this event. Justice and peace will run like a river, and I'd like to conclude my welcoming address. Thank you. Thank you, President Park. This time, it is my pleasure to invite Dr. 송상현, former president of the ICC. Please join me in giving him a warm round of applause.
Good afternoon, ladies and gentlemen. It is my great pleasure to welcome the international law experts to Seoul and offer my huge congratulations to the International Symposium on the legal implications of North Korea's military involvement in Russia's war against Ukraine ever held in Korea. First of all, I would like to extend my congratulations to the Korean Society of International Law and 송상현 Foundation for International Justice, Peace, and Human Rights for organizing this event. It is just timely and meaningful to start such an academic endeavor in Korea, as Kim Jong-un, the North Korean supreme leader, has assisted in Russia's war against Ukraine. We therefore attach great importance to this international symposium held in Seoul. It is the UN COI report written in 2014 by Australian Justice Michael Kirby that recommended for the first time that the case be referred to the ICC for judicial intervention. We are still grappling with the idea of holding perpetrators accountable. Accountability will help achieve sustainable peace and stability on the Korean Peninsula. The newly created ICC, the global champion of the world peace through justice, has influenced the international law and order and shaped the legal scholarship throughout the world. I think that time is right to bring Kim Jong-un before the ICC. Given Pyongyang's bold military assistance to Russia, Ukraine now has a legal standing to pursue an ICC case against the North Korean leader. In March 2023, the ICC issued arrest warrants against Vladimir Putin, causing a huge stir in the international community. Similarly, there are growing calls for North Korean leader Kim Jong-un to be held accountable for providing weapons and ammunition to Russia that were amply confirmed by satellite images. Since Ukrainian authorities can verify the use of these military supplies against Ukraine, North Korea would be implicated in aiding and abetting war crimes as outlined in the Rome Statute, the founding document of the ICC. It is assessed that North Korea's actions fall under the Article 25, paragraph 3C of the Rome Statute, which covers, I quote, facilitating the commission of such a crime, aids, abets, or otherwise assists in its commission or its attempted commission, including providing the means for its commission. The end of the quote. Earlier, I thus argued elsewhere that Article 25 of the Rome Statute clearly would establish Putin as the principal offender in the Ukraine war and Kim Jong-un as an accomplice, depending on the collection of evidence and the development of the situation. Especially after Kim recently deployed its own foot soldiers in Ukraine, he could even be prosecuted as a co-perpetrator with Putin now. Kim dispatched foot soldiers to Ukraine twice before, and just a few days ago, as you know, pledged to dispatch 6,000 soldiers third time. The Rome Statute provides for only two ways to bring a case to the ICC. Either a complaint is filed by the government of the affected country, or the UN Security Council refers the case. So far, neither of these conditions has been fulfilled. However, since North Korea's war crimes in Ukraine have been amply confirmed now, there is an opportunity for the Ukrainian authorities as the victims to file complaints against North Korea with the ICC. While a complaint filed by the Ukraine government would be most ideal, the ICC prosecutor also has the authority to initiate an independent investigation ex officio based on Article 13 of the Rome Statute. According to this provision, if he decides to proceed, a legal authorization must be sought from the ICC judges. The prosecutor's independent power of investigation has been exercised many times, by far I think eight times, including in cases involving Kenya and the Philippines. Therefore, the ICC prosecutor may bring criminal prosecution against North Korean leaders with respect to crimes that they committed in the territory of Ukraine. The eminent international legal scholars participating in this symposium would present their legal arguments and views on why North Korean leader would fall under the ICC jurisdiction. The most severe punitive effect is that an ICC arrest warrant has no statute of limitations, meaning that the accused must carry a stigma for their entire life, which itself is a significant psychological punishment and a conspicuous symbol of illegality in the international community. Additionally, war crime suspects, including Putin, face de facto punishment as they are prohibited from setting foot in any of the 120 ICC member states. Putin recently decided not to attend the BRICS meeting convened in South Africa, an ICC member state, for fear that he might be arrested locally. This is because ICC member states are obligated to arrest and transfer suspects to the ICC. Efforts to punish or sanction rogue states internationally have proven limited. In this context, the ICC's efforts to take action against leaders committing international crimes are highly commendable. It is hoped that the ICC will actively address the crimes committed by North Korean leader and his associates as revealed through the Ukraine war. I believe that the birth of the ICC 22 years ago has changed the way the world has come to think of and respond to international criminal justice. The ICC's judicial interventions contribute to establishing lasting peace as a key element in reconciling societies and ending cycles of violence. By helping the entrenchment of strong legal and societal norms that prohibit massive crimes and human rights abuses, the Rome Statute system can help us move toward a safer world in which people around the globe can live and prosper in peace. However, this is not a task for the justice sector alone, and international development agencies such as World Bank, IMF, UNDP, etc., would have to play a more positive role, such as sharing an initial justice costs with the ICC. It is also a goal that can be achieved only with the simultaneous strengthening of democracy, development, and the rule of law. Unlike in the past, the domestic criminal justice procedures of each member state become all organically interconnected with the ICC at the center. A global and comprehensive international criminal justice system has thus been emerged with close cooperation of various international or regional agencies and relevant non-governmental organizations or civil societies when necessary. Just 30 years ago, who would have thought that the international core crimes such as aggression, genocide, war, and crimes against humanity would be prosecuted by an independent, permanent international institution, and that investigating such crimes would become the expected norm rather than a rare exception. The ICC set up an entirely new paradigm of international criminal justice, which has made accountability for atrocity crimes an integral aspect of the rule of law. I hope that the states will take active part in the collective efforts of the international community to strengthen the rule of law, which is one of the most effective ways to increase the chances of peace, stability, and the well-being of the world. There are many challenges: competing interests, limited resources, political opportunism, cultural differences, different visions, and so forth. But at the end of the day, there are also undeniable shared values and common goals that humans everywhere hold dear. Men, women, and children everywhere want to live in a world of peace, security, and harmony without fear of violence and suffering. I hope that this symposium should encourage and inspire the next generation of leaders and actors just like you for universal criminal justice, as the ICC will continue its mission from now into the future as a giant leap forward in the global fight against impunity. Thank you very much.
Thank you. That was welcoming addresses, and we're about to start session 2, and we will now proceed with a group photo session with our distinguished guests, session chairs, and presenters and discussants. Our distinguished guests who were named before, and presenters and discussants, please come to the stage. Thank you. Please remain where you are. We are going to have another photo session with other attendees. If there's no one else, please return to your seats. We were going to have another photo session, but if you want to take a photo with our panelists and presenters, you can do so after the event is concluded. We will begin part 2 after organizing the stage. In the meantime, we will have a short break. On your right side, we have refreshments and coffee. Please feel free to take some. And from part 2, presentations will continue. So if you need to take a break, please do so right now. Thank you. Now I'd like to invite the MC, who is Professor Park Hoon of University of Seoul. We have Professor Park. Please give him a round of applause.
네, 방금 소개.
Hello, I'm Park Hoon from Seoul University of Seoul, and I'm a Secretary General at Seoul 송상현 Foundation. So session 1 was led by host, an announcer, and I'm an amateur, so please bear with me. And as a host of this event, I'm happy that so many people are here, but the refreshments are all out. So we will refill the refreshments as soon as they are ready. The hotel is now preparing the refreshments. And let me give you housekeeping announcements for session 2. Session 1, we heard opening and welcoming remarks, and yeah, so we took a group photo, but as you have seen, not everyone comes out to the podium, so we just took photo once. And in session 2, we will listen to the presentation, and then it will be led by panel discussion. There are some speakers who prepared deck, and so there in both session 2, 3, 4, the speakers will use the deck, and there is one discussant who couldn't join in person, so he sent a video. And Professor Taehyun Choi will give presentation first, and Professor Lee Yoon-jae will be joining via video, and then we will arrange desks and chairs to listen to panel discussion. So I am letting you know that the session is opening, and then each moderator will take over. So session 1 is about issues concerning the establishment of an ad hoc tribunal for the crime of aggression against Ukraine. So Cheol Gyu-hwang, immediate past president of International Association of Prosecutors, will be our moderator. Hello, I'm Taehyun Choi. I'll be giving a presentation on issues concerning the establishment of an ad hoc tribunal for the crime of aggression against Ukraine. And as you are well aware, 3 years ago, on February 24th, Russia launched an aggression against Ukraine, and ICC identifies 4 crimes, and we believe Russia falls under these 4 categories of crime, and currently investigation is being conducted, but the 2 crimes are the focus: crime against humanity and war crimes. And genocide, there's no confirmation yet. And about crime of aggression, we will look into it later, but it's a crime regulated by ICC, but under the current ICC framework, especially according to the Kampala amendments, ICC cannot exercise its jurisdiction over the Russia-Ukraine war. So how are we going to punish the crime of aggression? The proposal is to create an ad hoc tribunal or special tribunal. So that's what's being discussed now. And in the past, Russia or Belarus leaders, there were some proposals to set up a special tribunal against Russian or Belarusian leaders, but recently North Korea sent weapons, war supplies, and dispatched troops to Russia-Ukraine war. So now there is a new proposal to set up an ad hoc tribunal to punish North Korean leaders, but there are no specific plans yet. But recently, actually on May 9th, EU Commission and Council of Europe they worked with Ukraine and announced the plan to set up a special tribunal. So now they are working on it, but there are no specifics yet. So what we discussed here today would be incorporated in the EU's plan for establishing ad hoc tribunals. So before getting into the main point about Russia-Ukraine war, on which alleged crimes North Korea can be punished. From August 2023, North Korea has supplied shells, ammunitions, and anti-rockets to Russia, and since October 2023, North Korea has sent troops to Russia. So North Korea is deeply engaged in crime of aggression and war crimes of Russia. So on page 1 of my presentation, it said, this cannot be done without the consent of Kim Jong-il, North Korean leader. Oh, sorry, that's a typo. It's Kim Jong-un. So yeah, please understand that it's Kim Jong-un. So North Korea might be prosecuted as based on crime of aggression and war crimes. So shells, ammunitions, tanks, and anti-tank rockets supplied by North Korea were used by Russia in the war, and there are many such evidences, especially North Korean missile is not really good at targeting the right target or goals. So there were a lot of collateral damages of civilians. So North Korea can be considered as, there are some arguments that North Korea can be considered as a complice or co-perpetrator of Russia. Russian troops were dispatched since October 2024, and they were engaged in operations in Kursk, but I haven't seen records that they committed war crimes. So we cannot say that they are principal offenders, but North Korea might be prosecuted as co-perpetrator or accomplice. But as Professor 송상현 previously mentioned, Article 25, Paragraph 3 of Rome Statute might apply. So the war crimes committed by Russian troops, did North Korea aid or abet to the war crimes committed by Russian troops? So then, if that's the case, North Korea can be considered as an accomplice to the Russia. And about crime of aggression, based on the international law, North Korean troops sent to Russia, it can constitute crime of aggression, because North Korea sending troops is a clear violation of the principle of non-use of force under Article 2 of UN Charter. The constituent of, those who consider constituents of crime of aggression conservatively say that North Korea never attacked Ukraine. They just did operation in Kursk. So that in such a case, North Korea's troop dispatch doesn't constitute crime of aggression. But still, I think in such a case, Kim Jong-un can be considered as an accomplice, because although North Korean troops only did operation in Kursk, it can constitute as aiding, abetting, or assisting Russian troops. If North Korean troops didn't participate, then Russia would not have continued their operation in the East region, or so in other words, North Korean military activities contributed to Russia's war operation. So based on the Rome Statute and UN Charter, Kim Jong-un can be considered as accomplice. So how can we hold Kim Jong-un accountable? And ICC, so we will need to look at whether ICC's jurisdiction is held. Ukraine recently, on October 27th last year, ratified Rome Statute. And January 1st this year, Rome Statute took effect for Ukraine. So all the crimes and core crimes committed since then are under the jurisdiction of ICC. But before that, Ukraine declared the temporary acceptance in 2024 and 2025. So Ukraine accepted ICC's jurisdiction temporarily, and especially the second declaration is open-ended for all the crimes committed after 2024 fall under this ICC's jurisdiction. But Ukraine is now a member of the ICC, so I don't think the jurisdiction would be an issue. But the crimes against humanity and other crimes that occurred before ratification can be an issue. But Ukraine, the crime of aggression and crimes committed by Russia in the territory of Ukraine, Ukraine actually punished such cases. And as you know, there is the principle of complementarity, the complementarity principle under the Rome Statute. And if Ukraine takes the case to their own domestic court, then ICC cannot intervene. But if Ukraine court is unwilling or unable to prosecute crimes committed by Russia, if ICC views so, or if Ukraine wants to refer the case to the ICC, then it's called self-referral. Only in such cases ICC can prosecute crimes and hold trials. So Ukraine is currently conducting investigation on crime against humanity and collecting evidences. But if the prosecution is done in the domestic court of Ukraine, then ICC cannot intervene. But if ICC considers that the Ukraine prosecutor's office or court is unwilling or unable to prosecute crimes, or if Ukraine chooses self-referral, then ICC can step in. Well, Ukraine, on October 27th last year, ratified the Rome Statute, and they accepted Kampala amendments to the Rome Statute. So it seems they accepted ICC's jurisdiction, but the thing is Russia is not a state party to the Rome Statute, so ICC cannot hold trial. So Article 15 of the Kampala Amendments, if you look at the Article 15, paragraph 2 of the Kampala Amendments, if the aggressor state is not a non-state party, it doesn't really ask whether an aggressor state or a victim state is a non-state party. If either of the state is not a non-state party, then ICC cannot hold trial. So that's an issue. So that's why there is a proposal to establish an ad hoc tribunal. And another thing is about the crime of aggression. Ukraine has conducted investigation and punished a few perpetrators. I'm not sure which page it's in. To be brief, so crime of aggression is called leadership crime. So a leader who has an effective leadership or dominance can be punished, but like Ukraine law didn't specify that, so they investigated all the small fish, such as like people in a lower level, but Russian show host or head of the church, so they were all investigated under the crime against humanity, but there were 3 people, Troika, who were not investigated. So the head of state, head of government, and foreign ministers, they constitute a Troika. So Troika enjoys immunity, personal immunity. So that protects high-ranking state officials from criminal or civil prosecution in foreign courts. So Ukraine was faced with challenges. Ukraine's prosecutor's office or courts investigated a lot of potential perpetrators, about 600 to 700, but this troika of Russia was excluded. So under the international law, a domestic court of one country cannot prosecute high-ranking state officials, especially this troika of another country. So they couldn't punish Russia's troika. And to overcome such an issue, a special tribunal should be established to overcome this state immunity. So that's the proposal made. And at first, on February 24th in 2022, Russia invaded Ukraine, and in the UN Security Council meeting, they deplored Russia's aggression against Ukraine in the strongest norm. But of course, Russia vetoed the resolution, and this resolution was supported by 81 member states. So they said Russia's aggression against Ukraine constitutes a violation of Article 2, Paragraph 4 of UN Charter, so Russian troops should leave Ukraine territory right away, but Russia vetoed the resolution. Then UN Security Council chose a resolution on the unity for peace, and it's directly related to Korea too. When there was a Korean War in 1950, at that time, the former Soviet Union vetoed the UN Security Council resolution. Actually, they didn't participate in the UN Security Council meeting, so some resolutions were passed. So later on, Russia joined the meetings and then actively vetoed resolutions. And when at that time, the resolution on unity for peace was first raised. So what that means is if a permanent member state of UN Security Council vetoes a resolution and UN cannot really strengthen peace, stability, and security, then UN General Assembly can hold an emergency special session. So in November 1950, the Unity for Peace resolution was first proposed, and in the emergency special session, after the Russia-Ukraine war, it was the 11th special session. So the Unity for Peace resolution means UN can make recommendation based on the resolution passed in the special session, and then they can suggest a collective resolution. So if peace and stability are seriously threatened, they can allow the use of force. But of course, there are legal restrictions. The UN General Assembly's resolution is not legally binding. It's mostly just a recommendation. But based on that, a country can take collective measures. So afterwards, when we looked at the reality, ICC cannot really exercise its jurisdiction, and also there is the issue of state immunity. So the Professor Philip Sands first proposed the establishment of special tribunal to punish Russia's war crimes and crime of aggression for the first time. And many high-level officials also submitted a statement and declaration in support of his proposal. So a lot of countries around the world joined the efforts, and the discussion has been made so far. I don't have enough time, so I will move on to the legal issues that should be considered when establishing a special tribunal. In case of Ukraine, in their own territory, crimes were committed, so there are three ways for them to prosecute those crimes. One is Ukraine's domestic court punishing perpetrators. But as I mentioned, the issue is that the Troika will be immune. It will enjoy immunity from such prosecution and punishment, because there is state immunity, and under state immunity, personal immunity applies. So Ukraine's domestic court cannot prosecute and punish Russia's Troika. Second way is that a third country court exercising jurisdiction over the crimes, but it's same. In such a case, a domestic court cannot criminally punish Troika of another country because of personal immunity. So the third way is if Ukraine or a third country cannot punish Troika, then the third way is to create special tribunal. So how should the special tribunal be created? It should not have domestic characteristics. It should be international. So that's the proposal being made. And the most important issue is whether to allow state immunity. State immunity should not be allowed. Only then the Troika can be punished. So when we look at these, if we look at the theory of state immunity, there's personal immunity and material or functional immunity. So personal immunity means that high-ranking state officials have an official status, so they cannot be punished in foreign courts during their time in office. And material immunity means that these officials perform official tasks, so that's why they cannot be punished in a foreign court. In case of aggression, like the aggressor wouldn't say they invaded another country, so they will be saying that based on political and diplomatic reasons they conduct military operations, for example. So how can we overcome this state immunity? So in case of personal immunity, to avoid or deny personal immunity, we quote this case of special court for Sierra Leone. So the most important foundations to deny personal immunity are two. One is the ruling of the appellate trial in the Special Court for Sierra Leone and ICC. And so President al-Bashir visited Jordan. Jordan is an ICC member state, so they should have arrested President al-Bashir, but they didn't. So it went to the appellate court. So the personal and material immunity of the head of state would not apply. That was what was ruled in the appellate judgment of appellate trial from the Special Court of Sierra Leone. And about functional immunity, there were a lot of foundations and justifications to deny functional immunity. So functional immunity offers immunity over the official performance of state officials. But in case of international crimes, functional immunity is denied many times. So international crime refers to crime against humanity, war crime, and genocide, excluding crime of aggression. So that's when functional immunity can be denied. And there were many such cases. And the evidence is that state immunity is only given to the state's sovereign act, but international crime cannot constitute the state act. And the case in example is the Pinochet case. The former president of Chile, Pinochet, when the forced coercion and torture committed during his presidency constitute international crimes, so functional immunity didn't apply. And also based on the theory of implicit give up of the state act, or the functional immunity is denied. And also the jus cogens prevails all the international standards. That's why trial is needed. So these are the justifications. And lastly, in Nuremberg, international military trial case shows, in case of international crime, in not just the criminal court, but the domestic courts of other countries should also deny both personal and functional immunity. It's page 17. It's actually page 33 in your handbook. So the Nuremberg IMT's ruling is there. So under certain circumstances, state immunity cannot apply to international crimes and acts condemned internationally. So the perpetrators cannot hide behind their status. So that's the foundation that can support the denial of immunity. So under certain circumstances and in the appropriate proceedings, not just mean international court, but also domestic court. So these perpetrators cannot hide behind their official position to avoid punishment in the appropriate proceedings. But that's for international crimes, but would it apply to a crime of aggression as well? That's an issue. So in the next page, it discusses whether the denial of immunity also applies for crime of aggression. ILI's ruling shows that those who represent a state cannot enjoy functional immunity. They can be only acknowledged of their personal immunity. But it only are limited to international crimes such as crime against humanity, war crimes, and genocide. So crime of aggression is excluded. So, and also, Professor Lee Geun-kwan is also going through deliberations, and UN International Law Commission also is drafting the document, and according to Article 7, only some international crimes are exempted from functional immunity in domestic and international courts. And there are examples, and crime of aggression is not included there. So that's where the controversy arises. So the issue now is ILI or ILC do not acknowledge denial of functional immunity for the crime of aggression. That's one issue. And another issue is for serious international crimes, a third party's court exercising universal jurisdiction is acknowledged in the international practice, but can it also apply to crime of aggression? Can the third country's court exercise jurisdiction over crime of aggression? It's not certain. So at least 18 countries acknowledge universal jurisdiction over crime of aggression out of 200 countries. So they can punish other states' head of state. And in the Pinochet case, Lord Millett said that the universal jurisdiction can apply to the crime against peace, which is crime of aggression. But the international law experts are divided. So if we look at important international law textbook, the advanced textbook still doesn't include crime of aggression under the targets of universal jurisdiction. So against this backdrop, leadership and state officials, in order not to allow state immunity for them, then special tribunals should be established, and especially international ad hoc tribunal should be established. Just like ICC. ICC denies state immunity. So, but because ICC cannot exert jurisdiction over the Russia-Ukraine war, the only way is to create a special tribunal, especially the international special tribunal. So in such a case, the most important requirement is what's international special tribunal. So then it's like appellate court of ICC, which dealt with al-Bashir case. They say the tribunal should be acting on behalf of the international community. So that acting on behalf of the entire international community is one requirement category. And another thing is the Special Court of Sierra Leone's appellate court did so. So it should exert jurisdiction for multiple countries. So these two conditions should be met. And the argument is to create the special tribunal that meet these two conditions, but there are also issues. So how many countries should establish a special tribunal to represent multiple countries or the entire international community? 2 countries would be too small. So for a special tribunal to be international, a certain number of countries need to participate. But if we look at the legal precedents, the minimum number of countries are not mentioned. So the legal precedents are not really manifest or clear. That's an issue. And the collective sovereign willingness is a foundation for the international tribunal. So that's the ultimate requirement. And how are we going to create a special tribunal representing this universal sovereign willingness? If UN Security Council makes a decision, according to the Article 25 of UN Security Council rules, then special tribunal can be established. But Russia will certainly veto the resolution. Then the resolution will not be adopted. So UN Secretary General, the representative of international agencies, should entrust his authority properly so that the country's collective sovereign will can be expressed. So to establish special tribunal, multilateral agreement should be signed, and it shouldn't just cover countries in a certain region, because it cannot say it represents the entire international community. So the best way to overcome this is the international body, and what's most possible is UN General Assembly's intervention is most needed. So I mentioned emergency special session. When the UN Security Council is paralyzed, then they will ask UN General Assembly to step in to support them. Then they adopt resolution in a emergency special session. Then a special tribunal can be set up in that way too. But as I mentioned, it's not legally binding, and it's only based on recommendations. So, but it can be considered that it expresses the will of international community. That would be a preferred way. And another thing is the agreement of stakeholders or relevant countries is needed, especially in case of crime of aggression. The countries that have direct jurisdiction is Ukraine court. And so Ukrainian court, based on the rule of special tribunal, they will entrust their authority to the special tribunal. But to deny state immunity of Troika, the special tribunal should be truly international. And the Council of Europe announced that the special tribunal will be formed. They made the announcement on May 9th, but it only includes Europe, not other regions. So what I would like to argue is this should be backed up by the UN General Assembly. In conclusion, that's one. And So the international special tribunals that have been set up so far always had an alignment of relevant countries. Nuremberg, Tokyo, International Military Trial, all got alignment from Germany and Japan, and the Special Court of Sierra Leone just because UN Security Council was involved, it was considered to represent international community. But Russia would not agree to set up of its special tribunal, and Europe is now working on setting up special tribunal. They are forming processes. But Russia in the past was a member of Council of Europe. So if Council of Europe adopts this rule, then it can constitute Russian agreement. But Russia recently left Council of Europe. Then if the Council of Europe without Russia reaches a multilateral agreement, then it wouldn't be considered that Russia gave its consent. So that limitation can be overcome with UN General Assembly's intervention. And then next is about the trials in absentia. And as Professor 송상현 mentioned, if arrest warrant is issued, then the accused cannot be free of this complaint for the entire life. So Russian criminals should stay in Russia. They cannot leave Russia. And then if although Europe sets up special tribunal, Russian perpetrators would not leave Russia, then they wouldn't they wouldn't be present in the trial. But then is trial in absentia allowed? Currently, trial in absentia is not allowed. So the defendant has the right to be to get criminal trial, to be present in the criminal trial under Article 14 of the Right to Freedom Agreement, and also so the UN Right to Freedom and Human Rights Committee should allow trials in absentia if necessary. So in the special tribunal, maybe the institutional measures can be set up to allow trials in absentia. So on behalf of the international community, the special tribunal should be set up in a truly international way. So a multiplicity of countries should participate in a multilateral agreement, and one way is to form a special tribunal through UN Security Council or UN General Assembly. So in case of selecting a regional model, mixed model, or international model, if it's supported by UN General Assembly or UN Security Council, then many limitations can be overcome. Thank you.
For session 1, we heard from Professor Choi Tae-hyun. Please give him a big round of applause. Before we arrange the tables, we have a video from Professor Lee Yoon-jae of Myeongju University. So we will have our discussion after watching the video. Is it ready?
이렇게 화면으로 토론회에
I am very sorry that I couldn't attend personally. So, I am very thankful to be able to participate in this symposium. Dr. 송상현 is my teacher, and the Korean Society of International Law is a society that I am a member of, so I find this very meaningful. And also, Professor Choi Tae-hyun is someone I greatly admire. He is an expert of international law, and he has explained the important facts about Russia-Ukraine war that began in 2022. I'm really thankful. The key issue of this problem began when Russia invaded Ukraine on February 24th, 2022. Russia's invasion of Ukraine constitutes a crime of aggression, which is one of the key international war crimes. I am going to call it Russia-Ukraine war. In the midst of this war, there were violations of humanitarian law, and there were many crimes in this war. The presenter from August 2023 mentioned that North Korea provided weapons and war supplies, and they dispatched soldiers in October 2024. So the presenter recognized this involvement of North Korea in this war. The responsibility of this war would come from different countries, including Russia and the North Korea. So I'm not going to mention. Where I am interested in is the specialty of crime of aggression, and I want to understand whether North Korea's act is crime of aggression. And my second point is about the establishment of special tribunal that the presenter also pointed out. To discuss these two topics, I would like to have a look at the two issues on page 60. International crimes, as you know, we have genocide and repatriation, war crime, and crime of aggression. We have ICC that has jurisdiction over these crimes. Historically, crime of aggression and crime of war are originated differently. So there are war under the traditional international law. The crime of aggression was not punished. However, after the World War I and II, except for certain exercise of right of self-defense, we have banned the use of force. And in the International Court of Nuremberg, we decided to punish the crime of aggression against peace, and it is now included in the jurisdiction of ICC. And according to Rome Statute, turning to page 61, you can see the crime of aggression. These are the characteristics of crime of aggression. These are committed by the leaders, political activities, and the military activities, they have a leader who commands. So this crime can be committed by the leads. And it has two elements, the invasion of a state and invasion of individual. And in Section 2 of Rome Statute, there is a discussion whether it is inclusive or exclusive. And the fourth characteristics is that because this is a crime of a leader, in the Article 25 of 3 in Rome Statute about crime of aggression, the Article 25 says that this applies only to the leaders. The Article 25 is about the individual's criminality, so meaning that crime of aggression is not applied to Article 25. So we cannot punish this leader in any form. And then I will move to the North Korea's responsibility. August 2023 and October 2024, we saw the dispatchment of war supplies and soldiers, and we learned that North Korea have been deeply involved in the war, and the presenter believes that North Korea should be held accountable for this action. And sending weapons, can this be a principal actor, or is this aiding and abetting? Let me have a look. Many advanced countries are selling war supplies, and I don't think this constitutes as crime of aggression under Article 822 of Rome Statute. Also, about dispatching soldiers, I think we need more discussion. To determine whether this constitutes crime of aggression, we have to look at these two aspects. First, to be able to name North Korea as aggressor of a crime of aggression, it should be a palpable violation of the international charter. So the number of soldiers and the content of the operation, the area, we have to review all these elements. I am on page 63. And second, the number of soldiers and operations and the region, this information is required also to be able to check whether it is a violation under Article 822 of Rome Statute. The dispatch, when we look at Rome Statute Article 822, dispatching soldiers, armed soldiers, a group of soldiers, unofficial soldiers, it seems that it is actually effective involvement in a state. And also, thirdly, the dispatch happened after 2 years and 6 months. So there is a question whether this really makes North Korea a principal actor. As we have seen previously about war, we have crime of invasion, and there are two types of war crimes, for invasion and war crime. And this distinction is under ICC's jurisdiction as well. In that case, about the launch of the war and the violation about the launch of the war and about the ongoing war, when we differentiate these two, North Korea's dispatch, some might argue that this does not, this applies only to the second part. If it is the principal actor, then it would be about Article 821 of Rome Statute, because Russia military's act is not finished. It is joining of the effort. But if you deny that responsibility, it has a different take because the war already launched and then another country joined after the war started. So this violates only the latter part when they joined in the middle of the war. And I will move to the next point. About the two types of war crime, I would like to discuss the establishment of international tribunal. South Korea and North Korea have special relations, so we need to consider something special. In the international society, Russia, Ukraine are discussing ceasefire under the leadership of with the help of the U.S. and sometimes this discussion goes well and sometimes it's halted. But the discussion is ongoing and there can be a ceasefire thanks to the discussion. So given the circumstances, Russia and the North Korea, I don't think there is a possibility of opening lawful procedure by the international society. And second point is about the relations between the North Korea and South Korea. Under the President Yoon's government, the tension between South and North was elevated, and it was really harmful to the country. When we start the procedure to prosecute Russia and North Korea's leader, it can worsen the relations between South and Korea. The political changes will directly impact us. Therefore, in the international society, the change of the North Korea's standing, we have to closely observe changes in the North Korea, and we need to promote lowered tension, and we need to improve the relations with the North. So we have to be very considerate. I conclude my remark, and I appreciate Professor Choi Tae-young for the presentation. Thank you.
그 1세션에 황철규 송상현재단 운영위원장님께서 1세
we will now invite the moderator, presenter, and discussant, Professor Kim Jin. Yes, so please wait.
안녕하세요. 이번 첫 번째
Good afternoon. My name is Hwang Chol-gyu, and I am the moderator of this discussion. We are overrunning the schedule, so we first want to listen to Professor Kim Jin before moving on to actual discussion. Professor Kim. Good afternoon. I am Professor Kim Jin of Gyeonggi University. Thank you for inviting me to this symposium. I also thank the Korean Society of International Law and 송상현 Foundation for opening this symposium, and also Honorable Professor Choi Tae-young, thank you for your insightful presentation. Russian-Ukraine war is opening a new paradigm about the international law. First, the crime of aggression, which has not been addressed in any other international criminal justice forum since the Nuremberg and Tokyo International Military Tribunal, has been at the forefront of the issue, and it is the first time that a non-party to the Rome Statute of the International Criminal Court and a permanent member of the United States UN Security Council, and Russia is the perpetrator of the crime aggression. And we have the common understanding of the international community, which is not easy to have. And in Korea, it provides an opportunity for the possibility of the holding North Korea's supreme leader, Kim Jong-un. So taken together, the direction and manner in which the international community responds to the case will determine the scope, operation, capabilities, and consequent legitimacy of the international criminal justice system going forward. So today's discussion is not only about accountability for the fall in Ukraine, but also provides an opportunity to consider the direction of the international criminal justice system as a whole. The presentation first examined the scope of the measures, and I have a few questions, and I would like to add some comment. So, about the issues and challenges surrounding the establishment of the special court and the securing legal legitimacy, I have prepared a question, but Professor Choi Tae-won already answered at the end of the presentation. My question was about the selective justice. I believe that UN should step in to secure the representativeness. And then Professor Choi mentioned that in May, with the European Commission, that was limited to Europe, so the representation might be limited. And I wanted to ask a question about this, but then he already mentioned that UN General Assembly's participation is needed, so I'm going to skip my first question. And separately from the establishment of the law, I think it is an opportunity to see and build a new mechanism for international society's criminal court. The jurisdiction is limited, which is quite different from Kampala Amendment, and Russia's invasion, crime of aggression, can hinder the international endeavor. However, conversely, taking this opportunity, we can feel the need for the punishment for crime of aggression, and we can sound an alarm. So we can also supplement the Rome Statute and complement the ICC system. An amendment of Rome Statute will improve the jurisdiction, and there is a great need for this. The justification and effectiveness of international criminal law system and the jurisdiction of ICC is quite limited, that we learned taking this opportunity, and the international community's view on this have some questions. And also about the crime of aggression, ICC has lots of assets, but we cannot utilize it when it is crime of aggression. So effectiveness is in question. Until we had Kampala Amendment, we had to go through lots of processes, and there are complicated calculations in each country, but rather than giving in to this limitation, we want to be ambitious morally to open a new chapter. And also, the Special Tribunal and ICC can interact together, which can be a great model. So when we decide the jurisdiction between the different sides, we can avoid the unclear or overlapping areas, and ICC will oversee the rest part after the special tribunal look at crime of aggression. So we need to be clear on what ICC can do, and sharing information, collecting evidence, how to do it should be decided specifically. We have Sierra Leone Special Tribune, and when there were other investigation entities, there were tensions, so we need to remember this. Crime of aggression is invading the sovereignty of a state, so whether the target should be an individual or a state, that is unclear, and we need to take note of this part. About the participation of the individual, and also when there is compensation, the definition will differ. So from now on, we need to start the discussion right now. And if we accept individual as a victim, we need to utilize ICC because it has more asset, and we need to start thinking about this right now. And lastly, if we deal with the responsibility of the North Korea, this time, unlike previous experiences, we have more evidence that can be collected by the third party. So even if we fail to hold North Korea accountable, the process itself will give us insights about how we can deal with North Korea going forward. So it will be a meaningful effort. The international community is facing a new phase in the response to crimes of aggression. The process of holding Russia's most senior official accountable will be an important test of international criminal justice system's future ability to uphold peace and justice regardless of the influence of the perpetrating state. The response to this incident could be a watershed moment for the international criminal justice system if it is accompanied by the establishment of utilization of an international criminal justice organization. We look forward to a more in-depth discussion with you in the future, but we hope that I have raised a few issues that will inform the long-term development of the international criminal justice system. Thank you.
국내적으로
International law and also about ICC. Professor Choi Tae-won is the prestigious speaker on this field. So the leadership crime is not punished at the moment, and to be able to punish them, he emphasized the need for special tribunal. And when we try that, the potential issues include state immunity and universal jurisdiction. And as you know, Professor Choi Tae-won is a leader of international law, and our discussants are prosecutor turned professors. So they had very practical approach. And Professor Lee Yoon-jae was designated for the special prosecution. That's why he couldn't join us today. The potential application and international law and political sphere. Professor Yoon-jae was quite conservative, and Professor Jin emphasized with the need for the special tribunal and covered what can we do in a practical manner. Professor Choi Tae-hyun and Professor Kim Jin and Professor Lee Yoon-jae, it was all very insightful. I don't think we have further discussion, and I would like to give the microphone to the floor for 5 to 10 minutes. Professor Lee Geun-kwan. I am Professor Lee Geun-kwan from Seoul National University. Thank you for opening this opportunity for learning. Today, I heard Professor Choi Tae-won's presentation was very insightful. On page 34 and 35, I have something to update the information. I am a member of Committee for International Law, and I'd like to point out that in 2022, this month, last month, IOC was continuing with its second round and about the crimes that does not apply material immunity. The crime of aggression is added, so I wanted to update you on this new information. ILI, you mean? ILC, you mean? Oh, he's a member of ILC, and thank you for your comment. Anyone else? I am representative of Justice for North Korea. My name is Jung Pedro, and I am learning the science of North Korea. I would like to get answer from any participants. Professor Lee Yoon-jae mentioned that because of the special relations between two Koreas, South Korea cannot intervene in the punishment of North Korea, and he had concern about this, and I think this will continue in the next session. But about the two North Korean soldiers, I am not sure whether he is hesitant of taking them to South Korea. I want to get some feedback about that. As the presenter mentioned, if we proceed with establishment of special tribunal to get the capacity to collect evidence, we can have this captured soldiers as the evidence for the investigation. I want to understand about this possibility. And in the UN General Assembly, to refer to this issue, you mentioned that they can do so. And Secretary General should step in. And I am not sure whether it's feasible, so I want to know more about the feasibility. Thank you for the comment. Professor Choi Tae-won. Professor Lee Yoon-jae and Professor Kim Jin gave me comments about this, and I got some questions from the floor. I will try to respond comprehensively. So to Professor Yoon-jae about crime of aggression, the criteria about crime of aggression, he posed a question. So crime of aggression is about the violation of launching the war. So after the war is launched, it is no longer a crime of aggression. That was his question. And I want to make sure that you have the correct understanding about this issue. So crime of aggression, and we have the elements as criteria. So we have a document about the criteria, and as to crime of aggression, the first one is that the actor planned, prepared, or launched, or exercised the crime of aggression. And these four are under or condition. So crime of aggression needs aggression, and once it happened, the individuals who planned is also committing crime of aggression. The one who prepared also committed crime of aggression, and the one who launched committed crime of aggression, and the one who executed committed crime of aggression. All they can be punished for crime of aggression. Because they are connected with or condition, the individual who did only one of these four can be convicted. In the case of North Korea, even if they joined later on to join the war, their North Korea's act can constitute as crime of aggression, even if they joined later. And the reason is that there is an action of aggression because 1974 in December there was a booklet from UN General Assembly. A Professor Yoon Jae presented this on page 61. So item 1 and 2. So in the item 2, among those activities, and when they asserted serious armed activities against other countries, armed force or armed group, armed informal armies, armed militia, when they are dispatched, the involvement of a country. So North Korea's dispatch is identical with this condition. So North Korea can be punished for crime of aggression. And probably they will be punished for executing because they were not involved in the planning and preparation part. And North Korea's action constitutes as crime of aggression because of these reasons. And then another point was that politically and foreign affair-wise, diplomatically, we need to intervene. We now have a new administration. We need to improve the relations with the North. I understand that. So consider the benefit of the country. We need to be prudent. I agree, but that makes sense. But about the punishment for their action, South Korea's position cannot be a critical factor. Crime of aggression is something the international community is working together to punish, and we don't have the force to deter such efforts. The European Council is working on this, and we cannot send request to the Commission just for the benefit of South Korea. For war, ICC can prosecute and punish, but even in that case, ICC will not consider South Korea and decide not to punish North Korea's involvement. I don't think that is feasible. ICC has their own right to prosecute and punish, and Europe will do so within their own rights. So to have a smooth relations between North and South, we cannot oppose to this international activities just because we want smoother relations with the North. And today's gathering is about reviewing legality and the possibility of punishment of crime of aggression. So this is more scholarship-related discussion. And currently, it was a preemptory norm violation, so we need to be abided by the international norm. for country's benefit. We cannot hinder the international norm and merit just for one country. Some may argue that, but I cannot agree with that. And Professor Kim Jin, this was almost a paper. Thank you for supplementing your comments to my presentation. I prepared my answers and incorporated it into my presentation because I saw that in advance. And I don't think there was a bigger question. And her comment was a great inspiration for me, so thank you. And from the floor, there were questions. So the first question was about leadership crime. Oh, what was the question exactly? It may be discussed in the later sessions, but about the POWs, can South Korea intervene about their status? Whether it's domestic law or international law, we need to protect them. Okay. Oh, we have a session dedicated to that. What I can say now is that about North Korea soldiers and the crime of aggression of the leadership of North Korea are irrelevant. The soldiers were captured on the battlefield. They do not decide the strategies of the country. So questioning them will not produce the evidence of crime of aggression. And about the possibility of intervention of UN, among the previous special tribunals, there were cases where the Secretary General stepped in and there were establishment of special tribunals. So there are plenty of examples. We are running over by 30 minutes, so we need to conclude. But is there anyone who has to ask a question right now? Or if not, we're going to conclude session 1. We have second and third sessions, so you can ask questions going forward. So now I will conclude the first session of the symposium. Thank you, Professor Choi Tae-yeon, Professor Lee Yoon-jae, and Professor Kim Jin. And also thank you all attendees. About the establishment of special tribunal, I hope that our discussion contributes. Thank you. We were going to have 10-minute break, but we're going to shorten it to 5 minutes. So we will resume at 4:25. We are going to have the moderator continue with the current seat arrangement. We'll see you in 5 minutes. Thank you. So let me begin the second session. I am Jung Seo-yong from Korea University, and it is my honor to participate in this symposium with prestigious speakers. In our session, as you can see, on news you heard about Ukraine war, and I think Koreans are more interested because the news was covered by many media and about North Korean soldiers. And we have young students, many young students. And we feel that they are the same people as Koreans. we cannot resolve everything emotionally because there are legal implications and concerns. So I think among the 3 sessions, the second session is going to focus on this one issue. So when we look at the program overall, you will know that we invited the renowned speakers of this country, and our speakers and panelists are experts who dedicated their whole life in this matter, and sometimes they were involved practically in these issues. They are theoretically expert. So our first speaker is Professor Lee Yong-ho. He is a professor of Law School of Yeongnam University, and he is also chairman of Advisory Committee of International Humanitarian Law and Korean Red Cross. I usually do not do tight time management, time control, but I am going to do so today. I'm going to give 20 minutes to Professor Lee Yong-ho. I'm going to turn your microphone off if you go over 20 minutes. We need to be that tight to be able to move to session 3. So, Professor Lee Yong-ho, you have 20 minutes. Good afternoon. I am Lee Yong-ho. It is my pleasure to meet you here and to attend here. I didn't expect this big audience when I prepared this speech. I should have prepared a presentation, but I only have my script, so I apologize for that. And another thing I want to mention is that I was mistaken about the due date, so my speech is going to be in the state of draft. Before moving on to my speech, I want to mention a few things. We have North Korean soldiers in Ukraine. Our discussion is mainly about their legal status. The crime of aggression and how to look at it, the responsibility, that is not included in my speech. About this part, our Professor Baek Bum-seok prepared that part to cover, so you will hear about that soon. So my topic covers 2 things. First, the North Korean POWs. What is their legal status? In other words, do they have the position as the war prisoner? To be able to tell that, we need to decide whether they are combatant or not. The legal status of combatant and prisoners of war are the same thing. And there are exceptional cases, but usually they are the different sides of a coin. And then the second topic is that if they are accepted as prisoners of war, the ones detained in Ukraine, should South Korea invite them to South Korea? That is the second topic. I would like to give you my conclusions first. For the first topic, do they have the legal status of prisoners of war? When we check the conventions, we have the criteria for combatants. In 1907, we have the rule for land war and about the treaty about prisoner of war, we have the criteria for combatants. So we can use this as the yardstick. There were other opinions from other literature, but I personally believe that the captured North Korean soldiers are prisoners of war. They have the legal status. That was my personal conclusion. And about the Humanitarian Rights Act, the civilians and militia and combat, there are 3 classifications. And I'm going to cover that part as well. And the second part is that, can we bring them to South Korea? We have Geneva Convention, and Article 118 is disputable because when the war ends, the POWs should be sent back to their countries. And the Article 118 should the North Korean soldiers should be sent back to North Korea because of the Article 118, or the article also gives the right to refuse to send back. If they have the right to deny, they can say that I don't want to go back to North Korea because there is human rights infringement. But about that discussion, my opinion is that theoretically that might be possible, but realistically, coming to Korea would be almost impossible. The reason is that Russia, the US, North Korea, they all have their own positions, and they will not accept South Korea's request. They are in a difficult positions in their own manner. So my speech will base on the comment that I just made. I think this is a risky time. You might want to doze off. And I don't have a PPT prepared on the screen. So against these adversities, I am going to push through. So please be attentive. I will do my best. So first topic was that whether they are who are they in terms of legal status? So according to the international law, North Korean soldier, the person, individual, how the international law look at them. As I said, except for exceptional cases like militia, mercenaries. Mercenaries are quite different, so they are an exception. In the 1977 additional treaty, it stipulated that they cannot be classified as POW. So it is banning mercenaries unofficially. So we don't have to discuss mercenaries because it is hard to exist. One thing to point out about mercenaries is that for North Korean soldiers, we have a stringent definition about mercenaries, and the reason is that the official legal combatants can constitute as mercenaries. That's why we have a tight stringent definition of mercenaries. So there's a fear of punishment. So it is unlikely. So we need to only look at whether they are combatants or civilians. The North Korean soldiers, about the status, whether they have the right to fight, and about the rule of land war of Hague, and in 26, and also in the additional protocol. The condition grew wider and wider to decide combatants. So North Korean soldiers can be classified as combatants, so they deserve the treatment as prisoners of war. But the dispute occurs because of guerrillas. Guerrilla is a relaxed form of combatants, and for guerrillas, Article 44 of Additional Protocol, guerrilla was a result of compromise. So guerrilla was accepted as a form of combatant, and there were issues because of this. There were principles of distinctions, and there were many different disputes, but in the additional protocol, we banned betrayal. You cannot pretend to be a civilian, but guerrillas are quite close to civilians because the form is quite relaxed. So how to strike a balance is a difficult point as to guerrillas. And then about civilians, in the additional protocol, in Article 5, civilians are defined passively. So except for this and this, the rest are civilians. That is the way they used the concept. So very special cases, they are combatants, and unless they are combatants, they are civilians. The dispute about concept of civilian is that because it was defined passively, I mentioned guerrilla. But this passive definition of civilian creates some controversy because it is silent with respect to guerrillas as combatants. But for guerrillas, there's no stipulation. So why guerrillas were excluded? There is a gap. And the reason is that civilians and guerrillas, when we classify guerrillas as combatants, there are questions about protection of civilians. So in the Article 44 and 3, the guerrilla part excludes civilian definition. So about the status of individuals, how should we classify North Korean soldiers? These are the views, and as I said before, my conclusion is that North Korean soldiers detained in Ukraine are the member of co-belligerent and they are incorporated into Russian, so they are either of the two, meaning that they wore Russian military uniform. And for the North Korean soldiers, we can see that as they have been incorporated into Russian military. And in the additional protocol, the country needs to have the entity, international existence. So even if they are wearing Russian uniform, they are dressed in Russian uniform, they are still North Korean soldiers. So they are co-belligerent of the war. So either way, they are considered combatants, and they have the status of prisoners of war. And the second point is about whether we can repatriate them to South Korea. I am rushing through and I'm wondering whether my message is being delivered correctly. Please ask more questions to the panelists, not me, after the speech. So the second topic, in summary, is that if we see them as POWs, can they be repatriated to South Korea? According to Article 118 of Geneva Convention, it stipulates that they need to be released and repatriated without delay after the cessation of the hostilities. So bringing about the topic and controversy of taking them to South Korea would be that the North Korean soldiers, if the soldiers say they don't want to go back to North Korea, do they have the right to deny? Can it be interpreted that it's included in the 118? But then I think it's possible theoretically from the Article 20 of rule of law, land warfare, and there are other conventions about POWs. So the Article 118 has been evolving. So the Red Cross also argues that if the human rights is violated in their own country, they can deny and not send back to their country. In that respect, the right to deny can be disputed and discussed in theory. However, the most important part is on Ukraine. Among the provisions, there are rights held by the country holding the POWs. When there are injured POWs and when they are being transported, how can they do that? So there are clauses around this. So Ukraine's attitude will be the most important. And Iran and Israel, when we look at the circumstances, the international community is quite cold. The US and Russia and Iran, Russia, the comprehensive strategic partnership, the Article 5, when we look at this based on the article, they don't choose something not beneficial to themselves. Will the North Korea agree to send the soldiers to South Korea? Even if South Korea opens its door, I think in reality, repatriation to South Korea will be difficult. So how to resolve this is the next topic. So in conclusion, the first topic, I think, is quite clear and it is safe. About the second topic, as I said, we have other countries around us, and Ukrainians' opinion will matter as well. And maybe going through neutral international organizations, maybe we can form the atmosphere where they need to be sent to South Korea, and bringing them to South Korea will be better for their human rights as well. So I think we need to be more proactive. That concludes my speech. Thank you. Oh, it was precisely 20 minutes. Professor Yong-ho mentioned two topics: the legal status of North Korean prisoners of war. They need to have the legal status, and Professor Lee believes that they do have the status. And the second topic was, if they don't want to go back to North Korea, what should we do? Especially for South Korea, we are very interested. To my understanding, the legal grounds and other things, when we take things account, he is, I think, hesitant. We need to wait and see. And maybe our panelists can discuss deeper on these topics. So the first panelist is Professor Baek Bum-seok. I'm going to give him 7 minutes.
Yeah, hello, this is Baek Bum-seok. Well, about this topic, I take this topic very seriously, and I have a lot to cover. But I don't have enough time, so I feel really sorry about it, because I am going to touch some sensitive topics, so I didn't really include everything in my paper. So I actually rewrote my argument, but I will try my best to keep time. And the basic discussions, as mentioned before, based on the principle of POW under international law, can North Korean soldiers be acknowledged of their legal status of POW as combatant? Well, the agreement is actually most stakeholders are aligned, and actually, but there can be more complicated discussions based on whether North Korean soldiers are combatants or mercenaries. But in April this year, Russia confirmed the dispatch of North Korean troops, so I think that addressed complex discussions. And Article 118 of the Geneva Convention says prisoners shall be released and repatriated without delay after the cessation of active hostilities. And as you are well aware, right after the Korean War, this POW issue was the hot topic, and there was no regulation on forced repatriation, and UN actually acknowledged the POW's free will. And as Mr. Yong mentioned, ICRC also explains that if a POW refuses repatriation and is exposed to real threats of fundamental rights violations if returned, the exception to return obligation shall apply, and forced repatriation is not acknowledged. And also, under the international humanitarian law, such principle is there, and the customary rules are also outlining the principle of banned forced repatriation, and like we cannot breach the right to life, and the third POWs should be sent to a third country that can protect them. And many legal precedents have confirmed the principle of prohibition of forced repatriation. So a country can be responsible for this taking care of POW. As you are all aware, POW, like North Korean soldiers, if returned, can face torture and sufferings. So based on the international humanitarian law, countries have responsibility to protect North Korean POW. So I think that argument is gaining gaining support from the international community. And in the transitional justice, also measures should be taken to prevent the secondary damage due to forced repatriation, and should respect the will of victims. And what I want to say is, in 2024-25, North Korean troops dispatched to Russia-Ukraine war, they can directly access North Korean socials, and it offers unprecedented opportunity to express the human rights violation to the international community. So, of course, North Korean troops are perpetrators, but they are also victims. So this shows the victim-perpetrator paradox. So the international community has will need to take a victim-oriented approach, and so the human rights violation suffered by North Korean troops are double-edged. So they are the troops of aggressor state, but they also are the victims due to state violence. So how are we going to identify and cure their damage and responsibility? That would be an important topic for transitional phase. And also by collecting evidence from North Korean troops, I think we can accumulate evidence on North Korean regimes, war crime, and crime against humanity. So North Korean troops are not just POW, but they serve as a living archive that can demonstrate how North Korean regime operates. So they expose the forced dispatch mechanism of forced dispatch, and they can provide specific information on the control system within North Korean military. So a lot of discussions are made on North Korean troops captured, and of course, North Korea is there is a strong pushback from North Korea and Russia's diplomatic intervention. But I think with firm principle and vision, we can overcome these challenges. And can I have 2 more minutes? Well, to be brief, I will explain about strategic approach. So Korean government should cooperate with ICRC and make the overall process transparent and check the free will of POWs. And also, Korean can cooperate with UN Refugee Organization. So although Ukraine didn't sign the convention to protect refugees, actually they can send POWs to a third country. And also we will need to remind the international community, especially if Russia urges the North Korean troops to be repatriated, then we will need to form opinion of other countries. Yeah, thank you.
Thank you. I am in pain as well to control. There is someone else who are urging me as well, so I apologize. We have another panelist, but we already have two important topics. One is to accept North Korean soldiers as POW to be accepted in the international community, and I think another panelist also agreed. And the second topic is whether we should repatriate them to North Korea. And I feel that two of them already do not agree. And Professor Peck also mentioned the human rights aspect of international law. And if time allows, later on, we can also dig into the actual clause in an act. But we can also hear about other aspects aside from the academic discussions. Moving on to our third speaker, we have Dr. Kim Hwae-dong, who is currently working in the Department of Law and Economics of Korea Military Academy. He is, in a way, part of the governments. Today's speech will be from his individual opinion. You have 7 minutes, Doctor. Thank you. I am Kim Hwae-dong. Our two speakers already explained a lot, so I felt that 7 minutes was not enough, but now I don't have much to discuss. I am relieved. I think 7 minutes will be sufficient for me. Not even sure what I can do, but about this issue, the first topic was that October 2024, we had the news from Korean intelligence that North Korea not only supplied war supplies but also dispatched soldiers, and then we were not sure whether they were capable of that, but then in December the camera captured North Korean soldiers, so it became clear. And also Russia and North Korea, they did not officially announce that they have North Korean soldiers in the war, but later on we have scenes of engagement, we have fallen soldiers, and they are captured and spoke North Korean language, so it became clear. And then Russia and North Korea still kept silent. And then I think it was April 17th, North Korea and Russia officially confirmed that there were North Korean soldiers dispatched to the war. So before the official acknowledgement, international law scholars were not sure about their status. And as Professor Lee Yong-ho mentioned in detail, they do have the legal status as combatants, and they do have the legal status as POWs. I think there's no dispute. Are they part of Russia, or are they co-belligerent of North Korea, or are they mercenaries? Probably not mercenaries, because they should seek their own benefit, but it is hardly that. They just received order from the North Korea, so they are not mercenaries. And as co-belligerent, they can be combatants, but then they can use Russian supplies for uniform efforts. We have Katyusha, which is soldiers for the U.S. in Korea, and they are Korean. They use the U.S. supplies, but their ID shows that they are Korean, and they are registered as Korean soldiers. But the soldiers in North Korea, they used Russian supplies and had Russian ID. This is quite unique, so we need to check this legally further later on. And about repatriation, they are now POW. They are POWs when they are combatant. Maybe you wonder what should matter because Russia and North Korea already admitted. Still, it is very meaningful because for the responsibility of the state, if they are part of Russia, Russia should be held accountable. And if they are co-belligerent, North Korea also need to be held accountable. That is about the responsibility of state. And about the repatriation of POWs, this was the same in Korean War. They are not returned right after the cessation of the war. We need the agreement about the POWs. And are they North Korean prisoners or are they part of the Russia? The law will apply differently depending on this fact. And about the mutual bilateral treaty, maybe this is because of the comprehensive strategic partnership between the two countries. I disagree with the opinion because individuals, this is only for in a state of war by receiving armed invasion from individual countries or several countries. I think this is based on this clause. Russia invaded Ukraine, and in the war law, both countries' territories are battlefields, and Kursk is now held by Ukraine, but then it is not to say Ukraine invaded Russia. So arguing that the partnership affected, I don't agree. And for other parts, the two speakers already mentioned, so I'm going to conclude my speech. Thank you. Dr. Kim Hye-dong also covered the same topics of the two speakers, and he added on by saying that, I think this was said by Professor Lee Yong-ho as well. Is it a separate North Korea soldier, or are they part of Russia? It is not difficult to determine whether they are combatants, but when we think about repatriation, this can be important because you need to negotiate with the party. So Ukraine, who should they speak to? Is it Russia or North Korea? It looks complicated, but about POWs, they already said that they don't want to go back to North Korea, which was shared through media. We have 3 to 4 minutes. You don't have to answer, but I think there are questions. So are you saying that we can bring them to South Korea or not? No one made this clear. So, but to my understanding, three of you, all of you, correct me if I'm wrong, we have the legal basis not to repatriate them back to North Korea. That's my understanding. Maybe the level varies, but it's based in treaties, but also in the Human Rights Act. So if we decide to not send them back, and then what happens? You can say you're not in a position to discuss that, but can you answer that for 30 seconds? In the Geneva Convention as a whole, we have one clause banning repatriation. I think it was Article 45 to protect civilians. The political opinion, and there's another one. So repatriation is banned only for these cases. So in other cases, it is quite, there's no other clause determining this matter. So it requires further discussion. As Professor Peck said, I think it's quite common. But as you know, for international law, this is not about legality of armed forces action. According to the humanitarian law, we only have one repatriation banning clauses, and I am not aware of others. So I find it difficult.
So, there's legal ground not to repatriate the North Korean troops, but this also is in the diplomatic arena. Professor Beck? Yes, so the discussion about North Korean troops is an ongoing issue, and this is a historical task that two Koreas should address together, and that's how we need to approach the issue of legal status of North Korean troops. So they don't just stop at a legal actor under the international law. So they are perpetrators, but also victims of forced labor. And also, they are leaving archives of the crime against humanity committed by North Korea. So they have multifaceted status because they can serve as a catalyst to facilitate the discussions between Korea. So very sensitive and strategic approach is needed. North Korean troops' human rights should be protected, but that precondition is not met by North Korean regime. So the most important legal principle isn't the principle of repatriation and release, but the principle of protection of POW under the international humanitarian law. So we will need to identify their evidence as a witness. So that's how we can contribute the peace of the Korean Peninsula. Okay, so that was a very diplomatic answer. It wasn't really direct, but Professor Peck said, considering different aspects, and especially given the transitional justice and evidence collection, these North Korean troops can be beneficial in addressing these inter-Korean issues. And Professor Beck deals with a lot of IHL issues, so he mentioned the importance. And then Professor Kim Hee-dong. So when a war occurs, most people here would be considered as civilians, but I will be considered as a POW. So this is directly related to me. But I whether North Korean troops should come to Korea or they should be repatriated to North Korea. Well, Article 118 of Geneva Convention was previously considered as the right of a country, but it's actually the right of the POW. So this is not a policy issue, but the free will of POW is important, and that free will should not be swayed by any external influence. So, of course, North Korean POWs would be tortured if returned, but if they are willing to go back and meet their family members again, then their will should be respected. But if they do not want to be repatriated, then that will should be also respected. And that was the case after the Korean War too. So many POWs of Korean War were sent to a third country at the time. So if we consider the humanitarian approach in Article 118, it's not about repatriating to North Korea or sending to South Korea. We should respect free will of POWs. Thank you, Professor Kim Hee-dong. So if we summarize what he said, I think we are all on the same page. But rather than making a decision solely based on the international law, but we should respect the willingness and will of each individual POW, and to provide help from the international law aspect. Of course, we will need to protect them from external influence, and we will need to respect their will. So where are we going to head towards? So this is not just about international law, but it's also about diplomacy, and there are many things to consider. So we had discussion about two important issues, and I was going to open the floor for questions. And so, but actually we already got a question, and we already passed time. So. And I hope Korean Society of International Law can hold another symposium for further discussion. This wraps up our session. Thank you. Have a responsibility to lead this symposium. So session 3 will start as soon as we are prepared. We will take a break time for about 5 minutes. There is a presentation deck for session 3. So Chair Keun-Kwan Lee will sit together with presenter and discussants and lead the session. So I will give you a housekeeping announcement again 1 minute before the start of session 3. And we hope we can end this symposium by 6:10. Okay, so we will start session 3. This is a really important topic, and it's a very complex topic, but we don't have enough time, so we couldn't give you enough break time and enough time for discussion. Please do understand. And this is a joint international symposium, and this session 3 has English speaker, and so this session will be all run in English, so please listen to interpretation, Korean participants.
My name is Keun-Kwan Lee, and I'm teaching public international law at Seoul National University. And during my intervention at the first session, I introduced myself. At the moment, I'm working as a member of the UN International Commission. It is my great honor and privilege to be working as a moderator for this very important international symposium. I just came back from Geneva last week. The reason why I'm mentioning this is that, first of all, my commission, the UN International Commission, has played a rather important role in the launching of this very important international judicial organ called the International Criminal Court. As you can see that, the ILC prepared something known as the draft statute for an international criminal court in 1994. And 2 years later, in 1996, the ILC, International Commission, it completed its work on something known as draft code of crimes against international crimes against the peace and security of mankind. So, because I'm from the Commission, let me just share with you some information relating to the Commission's contribution to this very important field of international law, that is international criminal law. And let me also mention that we are very honored by the presence of Professor Song, the former president of the ICC. Well, as I said to you, I just came back from Geneva, and his brilliant achievements and his stellar reputation in the field of international law and especially international criminal law, it made my work very easy on the international scene. So I'd like to express my sincere thanks and gratitude to Professor Song, who was my teacher. Okay, let me, due to the time constraint, let me just briefly introduce our panel and then go on to the discussion of this very important subject matter. First of all, we are very lucky to have Professor Marko Milanovic as our paper presenter. Well, he has a very impressive resume, but let me just single out just a few of them. So at the moment, he is working as Professor of Public International Law at University of Reading School of Law in the UK. At the University of Reading, he is working as a Director of the Global Law at Reading. And I also need to mention that he is working as a co-general editor of the ongoing Tallinn Manual 3.0 manual. And he is also working as a co-editor of the EJIL talk. And let me also introduce our two discussants. First, Professor Seung-Hyun Nam. She is working as a professor at the Korean National Diplomatic Academy. And we have also Dr. Ethan Hisuk Shin, who is working as for the group known as the Transitional Justice Working Group. So once again, I think we are very fortunate to have this panel, and I'm sure that we'll all get very enlightened by their presentation and discussions. Then without further ado, let me invite Marko to present his paper. You can just, because I think the audience has your PowerPoint slides, so you can just make a presentation from here.
Oh, I can do that.
Okay.
Can I borrow those so I can
Okay.
see the full slide
right, okay.
myself?
Yeah.
Well, thank you so much. So, thank you so much, Professor Lee, and thank you to Professor Song and the foundation for inviting me. It's a great pleasure to be here. And thank you for both of you, for serving as discussants. I mean, it is really a pleasure to be here. And I'm also very happy to see Judge Kwan here, who has tried many Serbian war criminals. And so I'm very happy to see him here in Korea. The topic of my presentation will be about whether North Korea's involvement in the war in Ukraine makes it a principle, a direct perpetrator, as it were, or simply as an accomplice to everything that Russia has done to Ukraine. And the bottom line conclusion is that in some instances, North Korea is a principal agent, is a principal actor, and is directly violating some norms of international law, including some most important rules like the prohibition of aggression. North Korea is directly committing aggression against Ukraine. In other situations, North Korea and North Korean individuals are accomplices, or potentially could be accomplices. This is, as you will see, sometimes a bit difficult to prove, both in the state responsibility context and in the individual criminal responsibility context, because of issues about intent and proving knowledge or intent, which sometimes is going to be quite difficult. So I will cover in my presentation, which you can have in the booklet, I will cover several sets of issues. So first of all, I will talk about the law of state responsibility. So as you know, that's the secondary rules of international law developed by the International Law Commission, which are to date regarded as customary in nature, which define in particular the issue of attribution. When is a person acting on behalf of a state, and which one? And that actually relates to the previous session, which talked a bit about whether a North Korean prisoner of war is a Russian prisoner of war or a North Korean prisoner of war. And then I will talk a bit about questions of complicity, again, under the law of state responsibility, and then I will move to the law on the use of force and international humanitarian law. So when it comes to questions of attribution, again, you'll all recall that this issue of attribution is about when a person is in law to be regarded as acting on behalf of a state. And the main rule we have there is the rule codified in Article 4 of the ILC Articles on State Responsibility, which is that the state is responsible for the conduct of its organs. A North Korean soldier is obviously an organ of the DPRK. They have that status under North Korean law, even if they wear a Russian uniform or are issued a fake Russian identity paper, right? They're actually still acting on behalf of North Korea. The only possibility that these individuals could not be acting on behalf of North Korea is codified in Article 6 of the ILC articles. This deals with a very rare situation where one state puts at the disposal of another state its own organs. So let me give you an example. We have the Supreme Court in the United Kingdom, obviously. Those same judges, same people, sit on something called the Judicial Committee of the Privy Council. Those people are the Supreme Court of several other states in the British Commonwealth. So when they sit as judges for, I don't know, Bermuda, they're not British judges. They're actually judges of Bermuda or Jamaica or whoever, yeah? So that's the kind of situation in which this rule was developed, right? There have been applications of that rule to joint military operations, especially under the umbrella of an organization such as NATO. But the cases like this one are comparatively rare, where North Korea actually gives 10,000 soldiers to Russia, puts them in Russian uniforms, puts them under Russian operational command. And the question is how this rule would apply in this kind of context. The best, I think, approach to this is to simply say that in a situation where North Korea retains some level of command and control over its troops in Russia, it remains responsible for what they do. There are North Korean generals there. They're the ones who issue commands to North Korean troops, even though they coordinate with Russian generals, right? The North Korean generals, I'm sure, phone back to Pyongyang every day. It's not like they are completely under Russian control. So this is a situation which, if you look at the commentary of the ILC on page 107, in the second slide on page 107, this is a situation that arises when an organ of one state acts on the joint instruction of its own state and another state. In these cases, the ILC says the conduct in question is attributable to both states. So the bottom line is this. A North Korean soldier operating essentially under joint Russian-North Korean command in Russia is acting on behalf of both Russia and North Korea, right? And that's okay. So if, to the extent that that question is relevant to the POW question that was discussed in the previous session, you can in some sense say the soldier is a soldier of both of these states. So that, I think, is the correct legal answer. There is a lot of other conduct that North Korea has engaged in that does not raise this issue, where it's obvious that it's only North Korea acting. When, for example, Kim Jong-un approves a transfer of artillery shells, of millions of artillery shells to Russia, it's obvious that it's North Korea that's doing it, right? So this issue of attribution simply does not arise. It only arises with regard to the question of people placed under Russian operational command. So in that sense, the conduct of those people on the battlefield is the conduct of both states at the same time, so conduct of Russia and a conduct of North Korea. So that's the framework of attribution. But then the ILC articles also have this special rule on complicity. This is very strange in some respects. Like if you think about the ILC articles as being about civil liability, in a sense, in most domestic legal systems, I'm pretty sure in Korean law as well, we rarely talk about complicity in civil liability. Like we rarely think about it in those terms. We normally discuss this in a criminal context. And there, many domestic legal systems draw distinctions. They regard principal perpetrators as somehow being more morally and legally culpable than accomplices. That a person who commits murder, for example, is more responsible than the person who sold them the gun. Yeah? In international criminal law, we don't necessarily want to make those distinctions because sometimes we think that the accomplice is worse than the perpetrator. But the ILC sort of tried to engage with this issue of complicity in Article 16 of the ILC articles. That's a rule that has provoked a lot of recent scholarship on this issue. If you want to know more about it, if you're interested more about it, especially those of you who are still doing their studies, you can find a very nice paper by Chatham House, by Harriet Moynihan at Chatham House, which is about aiding and assisting other states. And the ILC, as I said, under the then chairmanship of Rapporteur on State Responsibility, Professor Crawford, produced this article, Article 16, which was later approvingly cited by the International Court of Justice in the Bosnian genocide case in 2007. So you have the text of that provision at the bottom slide on page 108. The provision, Professor Lee will I hopefully not disagree, is a mess. It's not a great example of something that the ILC has written because it is contradictory, right? If you look at the rule, the key problem is this mental element of the rule. So it says that a state which assists another in committing a wrongful act is responsible for its assistance if it does so with knowledge of the circumstances of the wrongful act and if the act would also be wrongful for that state. The problem is this bit under A does so with the knowledge of the circumstances of the wrongful act. If you read the ILC's commentary on this issue, it actually contradicts the text of the article and frequently talks about intent to aid or intent to facilitate or with the purpose of assisting. And all of these are potentially different mental standards. So this issue is relatively straightforward if we're talking about North Korea's responsibility for assisting Russia's aggression against Ukraine. If North Korea provides thousands of soldiers and millions of artillery shells and knows there's only one thing they're going to be used for, which is to attack Ukraine, it is straightforward to infer, even in intent. If you need intent, you can say North Korea intentionally aided and assisted Russia's aggression against Ukraine. The problem, as you'll see, as I'll talk about it in a minute, is if we're talking about war crimes or violations of IHL. Did North Korea, for example, intend to facilitate Russian attacks against civilians or civilian objects in Ukraine? And that's not as easy. So for aggression, you can very easily say the only thing the millions of artillery shells could have been used for is to facilitate Russia's aggression. It's not as easy to say this for war crimes, for example, for attacking civilians. So that's the issue of complicity where this fault element is particularly acute. It is perfectly possible to have other complicity rules that do not stem from the ILC articles that might be specific to certain branches of international law, like international humanitarian law. For example, in the Nicaragua case, the International Court said that states are under a duty not to encourage violations of IHL by other states. And you have these issues of complicity addressed fairly briefly in last year's advisory opinion of the ICJ with regard to the occupied Palestinian territories, which you have on page 109 of the booklet. So, for example, the court said states are under an obligation not to render aid or assistance in maintaining the situation created by Israel's illegal presence in occupied Palestinian territory. This is an echo of Article 41 of the LC articles on aiding and assisting situations that arose out of a violation of jus cogens. That states have a duty to ensure that any impediment resulting from Israel's illegal presence in the OPT to the Palestinian people's right to self-determination is brought to an end, and that states parties to the Fourth Geneva Convention must, while respecting the Charter international law, ensure compliance by Israel with IHL as embodied in that convention. So, bottom line, by providing artillery shells, by providing soldiers, there's simply no doubt that North Korea is facilitating Russia's wrongful acts. Now, North Korea has also provided other forms of assistance that are not necessarily wrongful. For example, we just heard in the past few days that North Korea is sending deminers to Kursk. Well, maybe Ukraine is not going to like that, but a North Korean soldier who removes mines in the Kursk region is not necessarily thereby facilitating Russia's aggression against Ukraine. The Kursk region was, remember, a part of Russia which Ukraine had occupied. Yeah? So not everything that North Korea has done in terms of providing assistance to Russia is wrongful, but certainly providing weapons, ammunition, soldiers is wrongful. So that is straightforward when it comes to aggression and the prohibition of the use of force in Article 2, Paragraph 4 of the Charter. As I said, it is less the case when it comes to violations of IHL. Not every artillery shell that Russia got from North Korea is used to commit a war crime. Most of these artillery shells are used by Russian troops against Ukrainian troops. As a matter of IHL, this is lawful. As a matter of the jus ad bellum, it is aggression. But as a matter of IHL, it is nothing wrongful. It is also not something that is a war crime, that's criminal. Yeah? So in order to prove that North Korea is complicit in Russian attacks against civilians, one would need to draw first a causal connection that actually the assistance that North Korea has provided is used to attack civilians or civilian objects. And then one would need to prove, to quote Article 16 of the LC articles, that North Korea was aware, that it knew about the circumstances of the wrongful act. I need to be clear that this issue is of huge relevance for other kinds of conflicts, right? So, for example, both of my states of nationality, both the UK and Serbia, are selling weapons to Israel. From what I saw in the news, South Korea is selling some weapons to Israel. So the question is, if you sell weapons to Israel, or if we sell weapons to Israel, and we know there's a risk those weapons could be used wrongfully in Gaza, are we complicit? You see what I mean? And it's a question that has been litigated now in the UK, in Germany, in the courts of various other countries. So I'm not telling you what position you should adopt. But if you adopt a position that North Korea sending artillery shells to Russia is a violation of IHL, you can easily expose yourself to the critique that if you sell weapons to Israel, you are also complicit in violations of IHL. So, and that depends a lot on how you calibrate the mental element of these complicity rules. There are other rules of IHL that sort of apply here that are relevant for our analysis. One question is whether North Korea became a party to the armed conflict between Russia and Ukraine, and I think the answer to that is straightforwardly yes. So state practice is reasonably clear that simply sending weapons to one state does not make you a party to the conflict. So if North Korea only sends artillery shells to Russia, it does not thereby become a party to the armed conflict, just like if Germany sends weapons to Ukraine, it is not a party to the armed conflict. But the moment soldiers went there and they start shooting, that's an easy case, that North Korea became a party to the international armed conflict. Again, if you're interested in this whole set of issues, there's a good recent paper by Chatham House on Participation in Armed Conflict, which was written by Alex Ventker. So that sort of sums up my analysis. I think it is very easy to say that North Korea has violated international law. It is not something that is in doubt, right? I mean, it is a fairly straightforward question. The question is, how exactly would you qualify it in multiple ways? For aggression, it is easy. For violations of IHL, it is not. Personally, my view is that if you send weapons to a country and there's a serious risk that they would violate IHL with those weapons, you are potentially complicit in that weapons transfer. But then again, remember how that might apply to Israel. I will just say something that is not in my slides as my last remark, and that's the question of criminal responsibility. I will make 2 points on this. As was noted quite correctly in the first session, the ICC has no jurisdiction over aggression in this particular case. It does, however, have jurisdiction over war crimes or crimes against humanity that are committed on Ukrainian territory. Now, so far, North Korean troops have fought only on Russian territory, to my knowledge. Right? They helped Russia liberate, quote-unquote, Kursk, even though that actually is an unlawful use of force against Ukraine, because Ukraine had the right, as a matter of self-defense, to be on Russian territory. If North Korean soldiers cross into Ukraine, which there are indications that they might in the next wave of activity, then the jurisdiction of the ICC would certainly be engaged. The jurisdiction of the ICC, though, might already be engaged because of the weapons transfers. And this is a really interesting issue. So under Article 12 of the Rome Statute, the court has jurisdiction if the crime is committed on the territory of a state party. A question that is currently unresolved completely in the court's jurisprudence is about responsibility for complicity or other forms of liability that are not direct perpetration. So the situation is if on North Korean and Russian territory, North Korean individuals aid and assist a crime that is then later committed in Ukrainian territory. So the conduct of complicity takes place in North Korea or Russia, but the crime later is completed on Ukrainian soil. So that issue has not been touched upon by the court yet. The Office of the Prosecutor has, though, expressed its position that those kinds of complicity scenarios would fall in the jurisdiction of the ICC. If you want to see the latest statement on the subject, it is in a bit of a different context. It is in the draft policy of the ICC Office of the Prosecutor on Cyber-Enabled Crimes. I am a special advisor of the prosecutor on these crimes, and we have this policy which is now under consultation, and we make an explicit point that, for example, if you facilitate a crime on the territory of a non-state party, and the crime is later completed on the territory of a state party, the court would have jurisdiction. So that's one big issue. The other question, though, if you want to criminally prosecute a North Korean official, is proving intent. And there, the big question is Article 25 of the statute, which talks about aiding and abetting, but with the purpose of facilitating. And that is a high bar to cross. But then the next provision, 25(3)d, talks about intentionally contributing to a group of persons acting with a common purpose if you know about their common purpose. This is something that Judge Kwan has applied a lot at the ICTY, this idea of joint criminal enterprise. This is sort of what the ICC has in that respect, and I think you can probably make an argument that complicity type liability exists on that basis. So I will conclude here. Thank you so much.
Thank you. Thank you, Professor Milanovic, for the concise and powerful presentation. Well, as you can see that he approached this question first of all from the standpoint of attribution of state responsibility. And so he thinks that probably when it comes to ASEWA, Article 4 is more proper as compared to Article 6. And then he went on to the discussion of a very difficult question of complicity. So in that regard, he discussed Article 16, which he called rather messy. But I'm from the Commission, so I have to exercise the right of self-defense, but I'll refrain from that. And one of the reasons why it is very messy is that, well, there hasn't been that much state practice in that regard. So that's one of the problems. But now I think that, as you mentioned, there are some developing state practice in that regard, right? And so, one prime example would be a case pending before the ICJ. That's the case is basically Nicaragua versus Germany. And the official title of that case is Alleged Breaches of Certain International Obligations in Respect of the Occupied Palestinian Territory. So I'm sure that there will be some more state practice will appear, and I'm sure that international law scholars and practitioners will delve into this question in the future. And then he also, even though that part is not included in his PowerPoint slides, but he mentioned that some of the two questions relating to international criminal responsibility. And once again, thank you very much. And some of the questions you have raised will be addressed by our discussants, especially Professor Nam and Dr. Shin. And let me invite Professor Nam to take the floor, please. Well, okay, yeah, okay. So it's fine with you. Just go ahead, please. Okay.
Okay. Thank you very much for your presentation, and thank you for inviting me to this event. It's truly an honor to be here with such distinguished academics and former judges, so it's truly an honor. With regard to your presentation, I think, I read your article before, so it was very helpful in understanding the legal issues. So I agree with most of what you said, and I would just like to add a few comments and provide some questions regarding your presentation, particularly regarding the DPRK's acknowledgement of its sending of troops. So I will talk more about that. But with regard to the timeline of DPRK's involvement, if we go back, first, DPRK's involvement in the Ukraine war was first publicized in 2024 in September. There was substantial evidence provided by the Korean National Intelligence Service at the Korean Parliament that DPRK had been exporting weapons to Russia. The DPRK had been sending weapons to Russia and along with military personnel to aid in their operation and maintenance. And many of these weapons were reportedly used to attack main cities in Ukraine, including Kiev. So therefore, some have argued that the DPRK should be recognized as a belligerent party to the conflict for supplying these weapons. But as you mentioned, just merely supplying weapons would not be sufficient. There has to be some kind of resort to armed force and a direct form of hostilities. So this is clear that at that time, the DPRK was not a party to the conflict. But DPRK's status as a belligerent in the war became more apparent with the capture of 2 DPRK soldiers in January 2025. But even then, DPRK and Russia did not officially acknowledge the DPRK's involvement in the war, which led to other legal questions such as whether the acts of these soldiers could, as a matter of law, be attributed to the DPRK. So this issue of attribution was particularly difficult to prove, especially because many DPRK soldiers carried, as you mentioned, and previous scholars also mentioned, carried Russian-issued military IDs and were in Russian uniforms. Thus, it was unclear in terms of whether these soldiers were operating under North Korean Russian command. And you also mentioned about dual attribution, that it could be the acts of these DPRK soldiers could be attributed to both the DPRK government as well as Russia. But I wonder if whether this there was a recent acknowledgement by Russia and the DPRK that the DPRK did dispatch their own troops to the Ukraine war. So I think this could have some serious legal implications as well. For example, in the KCNA, it provided that the decision by both the DPRK and Russia was fully in line with the provisions and spirits of the Comprehensive Strategic Partnership Treaty, and called the dispatch of troops as the most faithful, practical expression for the implementation of the treaty. Moreover, the Central Military Commission confirmed that its deployment was executed under the order of the Supreme Commander, with reports indicating that leader Kim Jong-un plans to erect a monument in Pyongyang to commemorate their heroic achievements. So based on these facts, do you still think that there could be dual attribution? In other words, could the acts of DPRK soldiers be directly attributed to both DPRK and Russia, or would this acknowledgement itself be sufficient to say that their acts can be attributable solely to the DPRK? So that's one of my questions that I have. And also, maybe they're not an accomplice, but there could be purely a principle in this sense. So I think this acknowledgement, I wonder what your thoughts are on the acknowledgement and the legal implications. And also, in terms of the responsibility for aggression, I think the special tribunal will play an important role, as mentioned by previous speakers. But I think that Russia and DPRK will continue to justify its actions based on the Treaty on Comprehensive Strategic Partnership, and that it was an act of self-defense, as you are aware. So, but as you know, so I wonder what implications does the treaty have in understanding the situation. And as you know, the issue of self-defense could be somewhat a challenge because this standard for exercising self-defense is sometimes not very clear. The Article 51 says there has to be an armed attack, but in customary international law, it says that there could be just imminent threat, right? So with regard to these different standards and their argument that is an act of self-defense, how can we interpret this regarding when pursuing accountability for aggression? Because at the UN, there was not full support for the Western countries. There were some who opposed this, that it was an illegal act of aggression. Yes, so those are my questions. Okay, thank you.
Thank you, Professor Nam, for your. I'm very sorry to restrict your discussion, but under the circumstances, I have to be rather draconian, and I seek for your understanding in that regard. And by the way, I think she raised two questions, and that goes back to the title of this session. That is the DPRK as a principal or as an accomplice. So. Well, you addressed that question, but at the same time, you didn't give a very clear answer to that question. And so, in a way, Professor Nam delved into that question in greater detail. Right? So, first of all, again, we have to deal with the question of attribution based on her discussion. And then the second question is the relevance or otherwise of the allegation, let's say, by the DPRK and Russia, that this was the action was taken based on treaties. So what implication do they have in terms of international law? So I think they are a very important question, and especially the first question has to do with a great deal to do with closely related to the question of how to deal with the North Korean POWs as well. So I think they were very important questions. And so let me invite Dr. Shin to address the audience, please.
Thank you, Professor Lee, for the introduction. I'd first like to thank the 송상현 Foundation for International Justice, Peace, and Human Rights, and the Korean Society of International Law for organizing today's event and giving me the opportunity to speak as a discussant. We have heard from Professor Milanovic and other speakers today about the various legal issues and also some political issues involved in the North Korean military deployment. As I guess the last speaker of the day, I would like to discuss more about the practical actions that can be taken to hold North Korea and its officials accountable under international law, namely international human rights law and international criminal law. So you can find my PowerPoint presentations from page 117. And in terms of the international human rights law and international criminal law, again, they're two different branches of international law. But as you know, the procedural aspect of international law can be very different from the procedures under domestic law in most countries. And in terms of just keeping to the page 119, I guess I'll be making an assumption that there have been violations of international law on the part of the DPRK and its leaders. And there can be many grounds for assuming, for example, that the way that the North Korean state has been treating its own soldiers and its own military and civilian personnel, as well as the actions that its forces have committed on the battleground, may constitute various violations of international human rights law and possibly also international criminal law. And for example, I guess like the kind of rights that would be mentioned would be the right to life, the right not to be tortured, etc. And in terms of it's very interesting to note, for example, that North Korea is a member of the United Nations, so it has the obligations under Article 56 to promote human rights, and it is also surprisingly a state party to many of the human rights treaties, including the ICCPR, the ICSCR, and other major human rights treaties. So again, assuming that North Korea has indeed violated these obligations under international human rights law, the main mechanisms for addressing these violations in the UN system would be the treaty bodies, the special procedures, and the UPR. And moving on to page 121. So in the case of North Korea does not allow any individual communications to be submitted to the treaty bodies, but and it also has been very not so engaging with the state reporting obligations under most treaties, except for the Convention on the Rights of Persons with Disability. So we actually have a review coming up in August this year, but it's really debatable how much of the military deployment issue may be raised in this CRPD review. In the case of the special procedures, this is even less, I guess, judicial, but there are currently 46 thematic and 14 country mandates created by the Human Rights Council. And I would say the special rapporteur on the DPRK and the special rapporteur on Russia would be, I guess, the most relevant special procedures. For the thematic special procedures, again, the special rapporteur on extrajudicial executions, the working group on enforced disappearances, the working group on arbitration may have the jurisdiction to raise issues with North Korea. In terms of the other bodies created by North Korea, and I'm referring to page 122 now, There is currently, as you may know, the mechanism to investigate the DPR accountability in Seoul, and also a commission of inquiry on Ukraine. So these would be the avenues to raise these issues, especially with respect to not only international human rights law, but also international criminal law at the UN level. The UPR is also would be another very useful avenue, although the UPRs for North Korea and Russia are at least 4 or 5 years, 3 or 4 years away. So it might not be such a timely avenue. In terms of the international, and also it's possible to raise these issues in the domestic courts. I would also like to highlight that possibility, as well as the Human Rights Council resolutions addressing the human rights situation in Ukraine. In terms of international criminal law, again, it's not easy the procedural or jurisdictional issue is can be very restrictive, but the ICC may exercise jurisdiction over some of these issues, both especially for war crimes. With respect to the crime of aggression, as Professor Che and others have discussed earlier, there is an active discussion about the creation of the special tribunal for the crime of aggression against Ukraine. And although the actual text of the statute of the special tribunal has not been made public, the frequently asked questions that are available on the website actually states that North Korean individuals could potentially be prosecuted if evidence shows they played a significant role in the crime of aggression against Ukraine. So again, these are important options available. And lastly, I would like to mention that the domestic courts also have an important role to play. And in this regard, I would like to highlight that South Korea even though South Korea has ratified the Rome Statute and has passed an implementing law almost 20 years ago, we have still not ratified the Kampala amendments on the crime of aggression, and we still don't have any domestic implementation. Given that South Korea is more likely to be on the receiving end than the giving end of the crime of aggression or acts of aggression, it will also be very important and timely for South Korea to seriously consider ratifying these amendments and making the domestic legal changes. Thank you.
Thank you, Dr. Shin, for your very concise presentation. Well, as you can see that Dr. Shin, he worked very hard on this subject and prepared many slides. And I'd like to express my thanks to Dr. Shin for working as kind of, interpreter for Marco, so that he can adjust to the conference in a very smooth way. Well, we have just 5 minutes, and so before inviting Professor Milanovic to address the questions raised by Professor Nam, let me just take just one question. Okay. Professor Park, please.
I am truly grateful to your presentation. Thank you. I'm going to ask my question in Korean. Could you have a okay.
Yes, so if we look at your presentation, so thinking about responsibility, there's civil responsibility and criminal responsibility, and you mentioned that the state responsibility, you refer to ILC draft on state responsibility, but I think for legal framework, I have a question. So whether North Korea is like principal actor or accomplice should be determined by Article 25 of the Rome Statute. But I think this ILC draft is about international illegality, the theory of international illegality. But you refer to ILC draft instead of Rome Statute, so I wonder whether it's right.
Did you get the question?
Yes.
Yeah, okay, all right. Okay, then please address this question and then questions raised by Professor Nam in just 2 minutes, please.
Good. Punch me if I go above 2 minutes. So thank you for that question. I mean, I think the ILC articles are the right framework when we are assessing the responsibility of North Korea as the state, whereas Article 25 of the Rome Statute is the right framework for assessing the criminal responsibility of individuals who act on North Korea's behalf. So if we're talking about the criminal responsibility of General X, it is the Rome Statute, but if we're talking about the responsibility of North Korea as a state, it is the ILC articles, the RCWA. When it comes to the three other questions from my co-panelists, first on whether North Korea is a principal or an accomplice, to give a straight answer, it's both, right? It's both at the same time, or its role varies depending on the context. When it comes to aggression, it started as an accomplice. When it sent its troops, it became a principal perpetrator. Obviously on a much smaller scale than Russia, but still a principal perpetrator. When it comes to violations of IHL, though, it can only be an accomplice, right? Its responsibility is derivative unless we see North Korean troops directly committing war crimes, which, I mean, I have not yet seen evidence of. On the question of the relevance of the treaty between North Korea and Russia, I think the relevance of it is zero, right? If Russia is committing aggression against Ukraine, and everybody agrees in this room at least that it is, the fact that Russia concludes a defense treaty with 5 other states is legally irrelevant. It is still committing aggression. And Ukraine still has the right to fight Russia on Russian territory, not just on Ukrainian territory. So if Ukraine is present in Russia, Ukraine is actually there legally. It is defending itself, right? And North Korea attacking Ukrainian troops on Russian territory is an attack. It is not self-defense of Russia. On the final point about the relevance of the acknowledgement, I think the relevance is mainly evidentiary. You know, most of the time, states simply lie about these attribution issues. You know, one state hacks another state and they say we never did it, right? When you have this kind of acknowledgement, it's simply obvious that they did it, but both states still, I think, are responsible. Thank you.
Yeah, I didn't punch you, okay, but okay.
It was very...
right, okay. Well, at the same time, you're very effective in addressing these very highly important and complex questions. But I think maybe if we can further discuss some of the answers that you have given, but at the same time, once again, thank you very much. And well, I think I was asked to run this third session until 6:10. I think we have to wrap it up. And he's coming up onto the stage. Well, once again, let me express my sincere thanks to the co-organizers of this very important and very timely academic event, especially former Justice of the Korean Supreme Court, Mr. Kim Yong-duk, and Professor Park Byung-do, who is representing the Korean Society of International Law. Well, Professor Song, he gave a very excellent congratulatory remarks, and there I was struck by his. I was very struck by his speech. In particular, I was struck by the paragraph saying that, quote, "I believe that the birth of the ICC 22 years ago has changed the way the world has come to think of and respond to international criminal justice. The ICC's judicial interventions contribute to establishing lasting peace as a key element in reconciling societies and ending cycles of violence," end of quote. And I think the question we are dealing here with is posing a huge challenge to his normative wish, and I hope that the international community will cope with this challenge and will be able to further strengthen very important intellectual and moral legacy firmly put in place by the ICC under the scintillating leadership by President Song. And with that, I'd like to close this session. Thank you very much.
네, 3섹션 큰 박수 부탁드립니다.
Please give them a big round of applause. I have a few announcements regarding the event. Please return your interpretation device before you head home. Please remain seated. So far, 송상현 Foundation and the Korean Society of International Law has prepared closing remark, so please give him a big round of applause. Today, with the 송상현 Foundation and the Korean Society of International Law held this international symposium, and it showed how the bravery of this country, our academia, concerns about the future of Korea, but also the future of the world. We should. Rule of law and the right to seek happiness, to enhance the basic rights. We need to protect and defend these values, and we need to spread these values to the world. Korea in 2002, from the inception of the ICC, has participated actively in the effort, and Justice 송상현, and we also produced the second judge of Korea, Jung Chang-bong and Baek Ki-bong, are currently serving, and Korean government is contributing with financial means as well. Our results and discussions today, I hope that the founding spirit of International Criminal Court and the result discussed will contribute to the amicable conclusion. Thank you. We're closing this symposium here. Thank you very much.